When we're looking at legal issues, the key one that comes up, and the first one, is that of contracts. And contracts are simply a way of ultimately setting up the rules of the game so that if there is a dispute, that it can be resolved. Essentially, any contract is that you're saying that you will supply the following kind of product to a customer, and that that customer will pay you X amount of money upon receipt of that particular product. Now, when we're looking at these contracts, you have to realize that what you've been using domestically will not be sufficient for international use. These contracts need to spell out payment terms. And really, that's where this whole issue of Incoterms comes in that we discussed previously. These actually define where and under what circumstances title transfers. In other words, the buyer actually then starts owing you money. That's when there is a transfer of ownership. It will also spell out if there's any products or defects or other problems, how those will be resolved. And then another important issue is the protection of intellectual property. We'll go into that further in another module. Now, inevitably, somewhere in the process, you're going to encounter a dispute with a customer or a supplier. How you handle it is important. It's not only a question of something for your bottom line, potential liabilities, but it also reflects upon your brand. You want to be known as a reliable supplier. Now, because you're selling across borders, the usual kind of legal remedies to force compliance with the contract are not generally available. Going back to the very beginning, I described that international business, cross-border business, is like playing 3D chess. In other words, on one side you have the legal framework that you're working in. The other one is the business culture. It's sort of like a game of chess in that you know the rules and so forth. And when you go cross-border, then there's another layer of that. And so then you're playing 3D chess. So what you have to do is you're going to have to figure out ways which the legal remedies can still work, or that you can at least protect yourself when they don't work. So what we're going to be looking at next is some steps that you can take advantage of in order to protect yourself. Now, generally what you want to do is to keep any dispute out of the legal system. U.S., European, whatever legal system. And here are some techniques that are most frequently used. The first one is, and this you can tell and spell out in your contract, is mediation. And that means that you have a neutral party who gets both sides of the dispute and that helps you to work through to come to some mutually acceptable solution. Now, a trained mediator is really worth the money. They're particularly helpful in fashioning what they view as win-win solutions among the parties. And the assumption is the parties are going to want to continue to do business with each other. And by coming up with this amicable kind of solution with a trained professional, that approach can save you millions of dollars. Taking this one step further is the concept of arbitration, and that's where both sides agree in advance to select a person, an arbiter, essentially a judge who knows the area, who can look at the case and make a decision. And that decision is binding upon both parties once they go down that road. It's unlike mediation, where in mediation you can walk away if you don't like how the resolution is coming out. The good part about binding arbitration is that it's can be a lot quicker and a lot cheaper, and it's one that both sides realize that they'll be win some and lose some. Now, if you're going to be using either mediation or arbitration, one of the most frequently used ways is called the International Chamber of Commerce, located in Paris, and it has good not only standard language for your contracts, it also sets out a series of procedures to resolve disputes, and it can put you in contact with trained arbiters and mediators who can act as your reliable neutral partner. You can see their URL down there when they're looking through that. Sometimes you just can't avoid taking a particular issue to a legal system. And it's one that it's a difficult one, but there are times when you'll need to do that. So then what you want to do is designate ahead of time in your contract exactly what is going to be, where legal issues are going to be considered and under what law. Now, the least favorable for you is a court system in a country with a poorly developed or highly politicized legal system. Their chances are that the other party can prevail because it's in their home country, or that the issue will become bogged down. Many countries, for example, will not accept oral presentations, arguments by lawyers, and insist on having everything written. This results in large, voluminous lawsuits that take a long, long time to resolve, simply because the judges have to sit there and write through them, and the lawyers also have to spend a lot of time preparing them. Now, one of the commonly used ones, particularly for U.S. exporters, is to say that the contracts will be carried out under a particular state's law. Generally, it's either California or New York. Both of those have fairly well-developed legal codes, commercial legal codes, that really are pretty up-to-date on dealing with cross-border issues. So, coming back to the beginning, you need to have a really well-drafted contract. The ones that you're currently using for domestic use will not be sufficient. And at the end, it's really worth paying the money to have good legal advice going up front so as to avoid a problem further on.